This is John Lynch from Lynch Solicitors in Clonmel with another one of our COVID-19 series. On the last one, this is part 2. Part 1 dealt with executors, or what I call the 3 wise men, now 4 wise men, and dealing with the other elements to that. The other elements to it would be the attorney created under the powers of attorney legislation, and effectively the powers of attorney legislation deals with that companion to the will. We call it a living will in the trade. And a living will basically is a document that comes into effect where somebody loses capacity. And the whole idea is that you're coping, or rather when you can't cope, you're trying to plan for that situation, and you plan for it by using a document called an enduring power of attorney. Now, the creation of an enduring power of attorney is fairly complex, or well, not so much complex as there are a number of steps to it, and I'm not proposing to go through those steps, but at the end of that, once the document is in place, that document doesn't get activated until such time as the person loses capacity. And when the person loses capacity, step number 2 then is to register the enduring power of attorney. And that registration phase effectively will empower the attorneys to look after the person's affairs. Now, a power of attorney can be a wide power of attorney, or it can be a narrow power of attorney. So in other words, you can decide on how much power you're going to give the attorney. Usually it's a good idea to appoint 2 people, and bearing in mind that at the registration stage, there is a facility there under the legislation, which in time will become under the decision-making authority, as in under the 2015 Act, which is an act that came in to add extra layers to enduring powers of attorney by providing for assisted decision-making agreements. Under that mechanism, a new institution, if you like, will be set up, or new body. Institution probably is too formal, but a new body will be set up, which basically is called the Decision Support Services. And that Decision Support Services will have a supervisory role and a registration role for the enduring power of attorney. But anyway, at the moment, that isn't in place, but I'm expecting that it should be in place quite shortly. And that will effectively mean that we will have a separate system dealing with enduring powers of attorney, assisted decision-making agreements. But under the current regime, we're talking about powers of attorney and we're talking about attorneys. So that effectively is the enduring power of attorney companion to the will. So you make your will that decides what you do when you pass on. You make your enduring power of attorney that the what if scenario if you become incapacitated. You appoint executors under your will. You appoint attorneys under your enduring power of attorney. Now, just to go back to the will for a second, there are 2 other wise persons or men that I'm talking about, and they are the guardians and trustees. Deal with guardians first. Guardians are relatively straightforward. Again, the same kind of imprimaturs that we put into executors. You should tell people if you're going to appoint them as guardians. You should talk to them about it. You should possibly do a document setting out your wishes for your children, all of which will be helpful to guardians. But the primary thing, I think, is to make sure that you tell them that they're being appointed as guardians, because it's a very onerous responsibility. And the other thing is you should make sure that you provide for them insofar as I would always feel that they should be remunerated. Remuneration probably isn't the right word, but they should certainly be given some incentive for taking on this very onerous responsibility. Now, so that's your guardians, and the same principle applies with guardians as with anybody else. You should trust them. You should make sure they know what you want and what your wishes are for your children, and you should make sure that they have the competence and skill set to carry out that very, very onerous responsibility of minding and tending for children. Now, the other one that you would commonly come across is, and this is in the context of wills, is a trust. And a trust document effectively is often within the will, and not everybody will be aware of the fact that they're actually creating a trust when they do what we call a wills trust. And a wills trust is just the one that you come across quite commonly, where you have young children, and as well as appointing guardians, you also appoint trustees. And in appointing trustees, effectively you give them the responsibility for the financial side of the situation should you pass on. And those trustees are literally there to hold the funds. So, for example, there might be a family home, there might be a pension payment, there might be cash in the bank, or there might be other assets like insurance policies and that. So they will effectively control and manage that fund until the children come of age. There's all sorts of issues, but they're kind of more will-making issues as to what age and what kind of powers do you give the trustees. Do you give them more powers than they might have under the Succession Act or the trustee legislation? But anyway, that's literally for another day in terms of how one might deal with that. So I think that's the extent. So when you're looking at what I call the 3/4 wise men, you're talking about executors who are there to execute your wishes under the will. You're talking trustees who are like your managers of your finance. You're talking about your guardians who are look after the care of your children. And then outside that, with your companion avert or addition of your will, which is your enduring power of attorney of your attorneys. And their job is to literally just carry out your instructions, look after you, and make those critical decisions that may need to be made in the context of your care or your finances that are an essential part of forward planning. Again, thank you. This is John Lynch of Lynch Solicitors, and thank you for listening to me.